Well, dude, I'll appreciate it. No appreciate it. I'm buying the new shirt for his.
No, I can do that. We got the food. So you did the same thing.
I've got a copy of my one.
Yeah, actually, we'll take that.
It's only slightly.
Let me get my robe on in front of everybody. A little bit different. No problem. You're gonna have my purse and everything, huh? Like a little purse.
At least we know you're not wearing pajamas on the road.
That's true. That's a good thing, isn't it? So right off the bat, I guess we're supposed to check for conflicts. So I guess you look around the room, see if you are close friends with anybody, and if there are no conflicts, we'll get started right away. Anybody have any conflicts so far? All right. We're going to be ready to go. Okay, so I understand we have a timer here. Who's our timer? Okay, we got a couple. Just going to ask everybody to make sure that their phones are off so we don't have any issues there. All right, good morning everyone. Welcome to this exciting event. I'm happy to be here. I will be presiding today. My name is Wendy Bruff. I am a referee for the Superior Court in Orange County, and I'm glad to be here. Then we have our other judges who will be doing evaluations along with me. So why don't we go ahead and get started. The court is calling the case of the estate of Peter Jones versus Dragon Studios. Could I have appearances, please?
Yes, Your Honor. Good morning. My name is Debnath. I'm joined at counsel table today, Your Honor, with my colleague, Mr. Luke Maverick Ryder.
Good morning, Your Honor.
And together we represent the estate of Peter Jones, the decedent in this case.
Okay, so you are the plaintiff.
Yes, Your
in
Honor.
this situation. Could I have appearances for the defense?
Yes, Your Honor. Good morning. My name is Jonathan Hubbard. Alongside me today, I have my good friend and co-counsel, Mr. Michael Ragnoni.
Good morning, Your Honor.
Good morning.
Your Honor, today we're representing Dragon Studios. At counsel tables with us today is the CEO of that company, Mr. Cole Doyle.
Good morning, Your Honor.
Good morning. All right. Now, does anyone have any preliminary issues before we get started on the case in chief?
Just a few housekeeping matters, Your Honor. We'd like to invoke Rules 603 and 615. Those constructively swear in and exclude all witnesses from the remainder of trial, barring party representatives such as Mr. Doyle.
That's a good idea. That motion will be granted. Anything else from the plaintiff?
Yes, Your Honor, just invite the court's attention that there's a number of pre-admitted exhibits 1 through 25. Would it be all right with you if we just reference that they're pre-admitted when we bring them up during trial?
Yes.
Okay. With that, Your Honor, the plaintiff's got nothing else.
All right. Thank you. Anything from the defense before we get started?
Yes, Your Honor. First, can we ask about your preferences for movement about the well? I understand we have a limited space here.
You do not have to inquire or ask permission. You may move as you see fit.
Yes, Your Honor. Does that specifically extend to going and approaching a witness, approaching the bench?
Yes.
Yes, Your Honor. Another housekeeping matter, Your Honor, is today, the defense prior to trial today had the option to pursue 2 affirmative defenses. That's assumption of the risk and comparative negligence of this action.
Mm-hmm.
Today, we've decided to pursue neither of those.
Oh, okay.
The plaintiff will have to pursue their case.
All right.
Yes, Your Honor, can I comment on that briefly?
Yes.
With that, the jury will be handed a verdict form that shows the defense has no burden in this case, and that means the defense has dismissed both affirmative defenses in a preliminary hearing.
All right. That's fine.
With that, Your Honor, we're ready to start.
All right. Are we ready for opening statements then?
Yes, Your Honor.
And would the plaintiff like to begin with opening statement?
Yes, Your Honor.
Yes, please proceed.
is about the call that never came. Members of the jury, we're here in court today because of this man. You might recognize him. Peter Jones was a famous actor known for his stunts. But this time last year, his production company had him do a stunt that killed him. It's June 21st, 2023, and Mr. Jones, he's on top of a mountain with a motorbike. He hurdles down a ramp. He jumps, drops that bike. He's in free fall. The only safety equipment? A parachute on his back. And an earpiece. See, someone in the control center for that set, they're supposed to tell him exactly what to do, exactly when to deploy his parachute to keep him safe. So he waits. 4 seconds. No call. 10 seconds. No call. The round is coming up faster and faster. 16 seconds go by. No call. Finally, he realizes that call is never coming. So in a last attempt to save his own life, he yanks that parachute cord. It's too late. His body crashes into the rocks. He dies instantly. The people responsible for that call that never came? The defendant, Dragon Studios. Members of the jury, that's why we as the plaintiff, we brought a claim of negligence against that production company. Now negligence, that means that they owed a duty of care to Mr. Jones to keep him safe while he was on that set. We're going to show you today that they breached that duty when they failed to make that call, and that's what caused Mr. Jones' death. We're going to prove that's true more likely than not with 3 facts. 1, that production company did too little to make that stunt safe. 2, they had him fall too low. And 3, when they finally tried to make that call, it was too late. So let's start with that first fact, members of the jury. How are we going to find out the production company did too little? Well, members of the jury, you're going to hear today that there was an original version of the stunt that Mr. Jones had practiced. He knew it in and out. But you learned the producer, Mr. Doyle. That wasn't enough for him. He wanted a more dangerous stunt, a more daring stunt. And that the first time they did the producer's version of that stunt, they had him do it with no harness, no safety equipment whatsoever, and Mr. Jones died. Fact number 2. They had him fall too low. Members of the jury, you're going to realize that the reason the producer's version of that stunt was dangerous is because they had Mr. Jones deploying his parachute at too low of an altitude. You're going to hear today that the stunt coordinator for that set never approved the producer's version of that plan because it wasn't safe. So that brings us to fact number 3. They were too late. Members of the jury, we're going to call an eyewitness to that stand who was inside the control center of that set with Mr. Doyle, the person who was supposed to make that call. She'll tell you that she watched as Mr. Doyle waited 1 more second than planned. Then another, then another, then another, until it was finally too late to save Mr. Jones's life. The one she watched as that call never came. members of the jury, that's why at the end of this trial, I'm going to come before you today and ask that you find the defendant liable. Thank you for your time.
Thank you. Now, would the defense care to make an opening statement at this time?
Yes, Your Honor, we'll do it now.
All right, go ahead and proceed. Yes.
Our plan was to protect him. It's June 21st, 2022, 1 year before this case started. And Colt Doig is sitting at a table in a conference room. He's feeling skeptical. The biggest actor in Hollywood just came up to him and told him he wants to do a crazy stunt. He wants to take a motorcycle 3,000 feet up a mountain, drive it off the cliff, and parachute to the ground below. It'd be the biggest stunt in Hollywood history. But you don't just tell the biggest actor in America no. So Cole does what he does for all his clients. He tries to make their dreams come true. Tries to make them safe. You're going to hear all about the things Cole did over that next year to make this safe. Fast forward 1 year. Cole is in position inside of a control room, getting ready to watch that stunt happen. At this point, he's already talked to all the experts he could, bought all the safety equipment he had. He's ready. And so Peter Jones, that stunt man, flies off that cliff. And as Cole watches, he sees him fall. And fall. And fall. And as the tragedy unfolds, Cole doesn't understand what's going on. He hired all the right people. He bought all the right equipment. His plan was to protect him. He doesn't know why this happened. And the truth is, members of the jury, nobody does. When tragedies like this happen, it is easy to pick someone to blame. The law says you can't just pick someone. It says that the plaintiff has to prove their case. Today, the plaintiff has brought a suit of negligence against Mr. Doig's company, Dragon Studios. What that means is that they have to prove his company was negligent, meaning that his company didn't act with reasonable care that a company should act with to protect its employees. They have to prove that it was that negligence that caused Peter Jones's death. They won't be able to do that today. They won't be able to do that for 3 simple reasons. The team, the training, and the technology. I want to walk through those one at a time. A few minutes ago, Ms. Debnath got up there, and she told you she promised she would prove that we did too little to make it safe. Members of the jury, what you're actually going to hear is that this company hired a team of experts 1 year before the stunt, that they worked on all kinds of safety measures, that they built ramps, that they built practice facilities, anything and everything to keep them safe. Then, you're going to hear about the training. You'll hear that this company paid for, mandated that Peter Jones take training to ride that motorcycle off. You'll learn that they mandated in a safety plan that Peter Jones has to do this stunt, has to do these trainings 1,000 times before he ever gets up to do it for real. And after you hear about the training, you'll hear about the technology. Because you'll learn this company invested in technology to make it safer. You hear that this company paid for these special parachutes that are quick deploying. Helps Peter land to the ground safer. And then you'll hear about that earbud. Ms. Debnath told you this case was about the call that never came, but members of the jury, you'll learn that this company set up a system to make sure it did. You'll learn that Peter had an earpiece in his ear, and that Cole was going to tell him exactly when to jump, and you'll learn that he did get that call. Like today's case, I want you to zoom out a little bit. Every time the plaintiff comes up here and tries to tell you about these individual moments, what they think happened, what might have happened, I want you to think about what we know happened. What we know this company did for the past year, what we know what their plan was. And if you do that, we're confident you'll see that our plan was always to protect. Thank you.
Thank you, counsel. I understand that the plaintiff has a witness to call. Is that correct?
Yes, Your Honor. The plaintiff calls Ellie Guggenheim.
All right, and we will presume that this witness has been sworn, so you can go ahead and be seated, and you may begin your questioning whenever you're ready.
Yes, Your Honor. Good morning.
Good morning.
Can you introduce yourself to the members of the jury?
Good morning, everybody. My name is Ellie Kugian.
What do you do for a living?
I'm a talent agent.
Do you work with your own company?
I do. I have my own company, represent a lot of actors out here in LA.
Ma'am, do you know who this is in Exhibit 3?
I do. That was my good friend, Peter Jones. I also represented him when he was working in the film industry.
Was he your client?
He was.
Ma'am, were you there to see what happened to Peter Jones on June 21st of 2023?
I was. I watched him die.
Can you tell the jury what he was doing when he died?
We was filming a stunt for his most recent film, All Lost 7. And he died performing that stunt.
Let's talk more about that stunt, Ms. Goodwin. Did you know how that stunt was supposed to go down?
Absolutely. We had a safety plan in place, a contract that I signed, Peter signed, the production company signed. There was an original plan of what was supposed to happen.
That contract and that safety plan, would you recognize those if I showed them to you today?
Absolutely.
I'm approaching opposing counsel with what's been marked as Exhibits 33 and 34. Your Honor, would you like a copy of each?
Yes. Thank you, counsel.
Ms. Camillo, you've got a binder in front of you. If you could flip open to Exhibits 33, we'll start there.
Okay.
Let me know when you're ready.
I'm on 33.
Ma'am, what is that?
This is the contract between Peter and the production studio for that film and the stunt plan involved.
Does it look fair and accurate to you?
It does.
What about Exhibit 34? Can you take a look at that?
Yeah, this is the stunt plan. It's talked about in the contract. We all signed this too.
That document as well, does it look the same as you last saw it?
It does.
The plaintiff moves to enter Exhibits 33 and 34.
Objection, Your Honor. Under Rule 702, if I may be heard.
Yes.
Your Honor, if you look at Exhibit 34, that stunt plan, at the last bullet point, you'll notice that it says, according to skydiving industry standards, and talks about specific expert opinions in that field. Your Honor, we don't believe 702 foundation has been laid for this, and we'd ask that the court strike it because they haven't met that foundation.
Your response?
Yes, Your Honor. We're not using the information in Exhibit 34 in this stunt plan for any kind of expert opinion. We're using it for the effect it had on the people who signed it. If you take a look at this document, Your Honor, Mr. Jones, this witness, as well as the representative of the defendant in this case, signed this document agreeing to its contents, meaning they agreed as well to this opinion about the 2,000 feet above ground being the industry standard.
And your response to that?
Yes, Your Honor. In her opening statement, Ms. Debnath told you she promised she would prove that they fell too low. This section of this stunt plan goes to show what a reasonable fall would be. They have to be using it for the truth.
May I be heard briefly,
Yes,
Your Honor?
briefly.
Your Honor, if I may proffer. Later in trial, we'll be actually reading prior testimony from a stunt coordinator who was on that set. That's where the information about what was safe and what wasn't will come from. For now, we're only using the information in this stunt plan for the notice of the recipients listed at the bottom of this page.
All right, I'm ready to make a ruling. I'm going to admit Exhibit 33, Exhibit 34 will be admitted with that last bullet point. I'm going to hold that particular paragraph in abeyance until further foundation is laid. So you can renew your motion to admit that particular portion of document 34 after some foundation is laid. Go ahead, continue.
So ma'am, taking a look at this overall stunt plan,
Okay, yeah.
what did it say about how the stunt was supposed to go down?
Well, I'll paint you a picture of what was supposed to happen. So Peter was gonna be riding a motorbike, right? He was gonna ride it off a ramp, and then when he was in the air, he was gonna drop the bike, and he was gonna get a call of exactly when it was time to pull the strings of the parachute.
When was he supposed to get that call?
4 seconds after we went into the air.
Who was responsible for giving Mr. Jones that call?
Kunde, he's the owner of the production studio that we were working on.
So maybe we can close that binder. Let's go ahead and talk about the first date that stunt was filmed.
Sure.
What date was that?
We started filming this stunt on June 20th, 2023.
Were you in the control center watching it happen?
I was, witnessing.
Who was with you?
Kunde.
Ma'am, were you and Kunde watching as that stunt began?
Absolutely.
How did it go at first?
On June 20th, we had 6 takes. They all went the exact same way. Peter drove the motorbike off the ramp, 4 seconds went by, and he got the call. Pulled the strings, landed safely, all 6 times.
After we landed safely those 6 times, did anybody say they wanted another take?
Yeah. That night, Kunde told us over dinner that the scene wasn't good enough. He wanted another.
When you say he told us, who did he tell?
Me and Peter.
Ma'am, you say that he wanted another take. Did he specify how he wanted the take to change from the last time it had happened?
Yeah. Kunde, he told us that he wanted Peter to be in the air a little bit longer before he was going to give him the call.
A little bit longer. Exactly how much longer did he want him to be in the air?
Right, for 9 seconds, instead of the 4 that we had planned in the stunt.
So after Mr. Doy said the new plan was a 9-second fall, how did Mr. Jones react?
He had questions. I mean, we both did. He wanted to know if it was safe, if the stunt coordinator that we was working with, he wanted to know what she thought.
The stunt coordinator, can you explain what that is?
Absolutely. The production studio hires a stunt coordinator, and it's her job to make sure that everything is safe. We execute the plan as followed, then we all sign.
So after Mr. Jones asked if the stunt coordinator had approved this new 9-second fall, how did Mr. Doy respond?
He said yes, that she had.
Ma'am, I want to be clear, were you ever able to speak to that stunt coordinator personally to see if it was true that she'd approved that plan?
No, she left after the 20th. We thought we were done filming the stunt.
So sitting here today, do you know if Mr. Doy was telling the truth about that stunt coordinator approving that plan?
I couldn't tell you.
So ma'am, after Mr. Doy claimed the stunt coordinator had approved it, how did Peter respond?
That's when he said yes.
Well, let's talk about how the new plan for the stunt was filmed. What date was that filmed?
The next day, June 21st.
Ma'am, were you in the control center with Mr. Dory again?
I was, I'll never forget that day.
Was there any way for you to see the time that Peter would be falling for inside that control center?
Yes, there was.
So how did that stunt start?
So it started off like normal. He was in the control room and I watched as Peter's motorbike, it left the ramp and he went into the air, dropped the bike, and then that's when he started falling.
How long did he fall for?
I mean, I'm watching the time, right? I'm watching the seconds go by, 4 seconds, 9 seconds. I'm waiting to hear the call, but the caller never came. He just kept falling.
Ma'am, at 9 seconds, did Mr. Doy make that call?
No,
At 10 seconds?
no.
Ma'am, did that call ever come?
No, I'm looking at Mr. Doig and I'm saying, what are you doing? You know, tell him to deploy, do something, but he stayed silent the whole time.
And after that call never came, what happened to Mr. Jones?
He fell out of the sky. He died on impact.
Did Mr. Dory say anything when that happened?
When I asked him, how could you do this? All he said is that he wanted a longer seat.
Did he say anything else?
I said, why didn't you ever make the call?
Did he respond?
No, that's the thing, he just stayed silent.
Thank you for your time, ma'am. Your Honor, I've got nothing.
All right, go ahead with cross-examination, please.
Yes, Your Honor.
Yes.
Good morning, Ms. Guglion. I'm sorry for your loss to hear that happened to Peter.
Thank you.
I want to talk to you about the entire range of that stunt.
Okay.
Because we could agree, this plan for that stunt didn't start on the day Peter passed away.
No, the original plan, the way it was supposed to go, the 4 seconds, we planned that a year in advance.
A year before, you, Mr. Doig, Peter, and a security expert all got in the room together, right?
That's right, we signed that safety plan that we was just talking about.
I want to talk about the preparation they did for this plan. Because, ma'am, we can agree, there was a team behind this stunt.
Absolutely.
We could agree that there were dozens of people doing different things at the stunt.
Yeah, we had to prepare.
People had different jobs to keep Mr. Jones safe.
That's right.
We could agree that Dragon Studios hired experts to figure out the best way to make this happen.
That's right, and we did. That's why we had a stunt plan that should have been followed.
Well, I want to talk about that stunt plan.
Okay.
Because we could agree in that plan it provides training that Peter should do, right?
Right, very specific training about the timing, when you would fall, when you would open the parachute.
Or amen, you know that one of the trainings is based on his motorcycle side of the stunt, right?
That's right.
On the motorcycle side, you know that he was to practice that 500 times.
Absolutely, yeah.
Man, would you recognize a photo of his practice site if I showed it to you?
I would.
Your Honor, may I approach the bench to give a
Yes,
copy to the
please.
town? And Your Honor, this is pre-admitted evidence. That's a photo of the training site, right?
That's right.
That's a photo of where Dragon Studios paid for Peter to train.
That's right. This is where we practiced the stunt like we had planned in the safety plan.
And he did do it. He did do the 500 times, right?
Yep, every time he opened his parachute after 4 seconds.
No, ma'am, this is just the motorcycle part, right?
That's right.
He didn't do the skydiving part at this point, right?
Well, during the training he did.
During the training of the skydiving part, but I'm just talking about the motorcycle part right now.
Okay,
So that's right, am I right?
you're right.
On the skydiving part, you know that he had to practice that another 500 times.
That's right.
So now that we've talked about that team And we talked about that training. I want to talk about some of the technology he had. Because you know that Dragon Studios paid for parachute technology that made it quicker to pull.
They did.
They equipped Peter with that technology, right?
They did.
You know that one of the pieces of technology that they paid for was an earpiece.
That's right.
Did it look like this?
It did.
Your Honor, this is pre-admitted evidence. Can I publish it to the jury?
What exhibit number is that?
This is Exhibit 4.
Okay.
The
Yes.
earpiece that was recovered.
Yes, you may.
Man, even that earpiece was something Dragon Studios came up with to keep him safe.
That's right. That's where Peter was supposed to get the call that day. Through that earpiece.
And I understand you're saying he was supposed to, that Mr. Doyd didn't give that call.
He didn't.
I want to talk about why you might be saying that today. Ma'am, you're a talent agent, right?
Right.
You own your own agency.
I do.
Peter was your client for years.
He was my client and he was my good friend.
That's right, your good friend. You made millions of dollars making movies with him, right?
We did.
Ma'am, you know that a talent agency should want to keep its employees safe, right?
Absolutely. That's why we had a safety plan in place that we were supposed to follow. Mr. Doyd decided not to.
Well, ma'am, that's the plan you signed off on, right?
I did.
Ma'am, to be clear, when it got changed to 9 seconds, you also signed off on that too.
Well, we thought the stunt coordinator had okayed it, so
And to be clear, to your knowledge, she actually did okay.
I never was able to confirm. I never talked to this guy.
Okay, ma'am, you signed off on 9 seconds though, isn't that true?
We didn't sign anything. It was a
You agreed to it.
conversation.
Ma'am, if people, potential clients, knew that you signed off on a plan that ultimately ended in Peter's death, well, that might not be good for business, would it?
Objection, Your Honor, speculation and lack of personal knowledge.
Your Honor, may I respond?
Yes.
Your Honor, she owns her own talent agency. I'm asking about her opinions on how current events could affect her own company. I'm not asking her to reach inside anybody's mind. I'm asking her to say, if this happened, do you believe your business would be affected? And that's within her personal knowledge, and it's not speculation.
May I be heard?
Yes.
Your Honor, at this time, defense counsel is asking this witness to consider the counterfactual, to go into the future and try to predict her own mindset for how this situation that did not happen would have affected her business. She can't step into that mindset to give any reliable testimony to the members of the jury. It's inadmissible.
The objection is overruled. Go ahead and answer the question. If you recall it, if you need counsel to restate it, that can be done.
If you could restate it, please.
Man, if people believe that your company or that your agency didn't keep Peter safe, well, that might not be good for business, would it?
If the plan that we signed off on was actually followed, Peter would still be alive. It wasn't, and that's not my company's fault.
Ma'am, I need you to answer the question. If people believe that you signed off on a plan where Peter ultimately died, that might affect your business. Do you think so or not?
I have no idea, because that's not what happened.
Nothing further.
All right. Do we have redirect?
Yes, Your Honor.
You may proceed.
Ma'am, just a moment ago, Mr. Jones asked about the team that the production company set up. On June 21st, 2023, inside that control center, was the entire team with you and Mr. Doyle?
No, they left. It was just me and Mr. Doyd. We weren't even supposed to be filming that day.
And who was supposed to make that call?
Mr. Doyd.
No.
Do you have any recross?
No, Your Honor.
All right. May this witness be excused?
Yes, Your Honor.
All right. And I understand you have no further witnesses. Is that correct?
That's correct, Your Honor. We do have, as I mentioned before, some former testimony from the stunt coordinator that we'd like to read onto the record at this time.
Okay. And is that in one of the exhibits in the material the court has?
Your Honor, it will be the deposition of Sky Stebbins, Exhibit 39, and I'm going to go ahead and show Mr. Hubbard so that we're all on the same page about what's going to be read.
Do you have any objection to that?
Your Honor, I wasn't made aware of what's going to be read. If I can just take a moment to look
Okay,
at it.
sure.
Yes, Your Honor, we do have an objection.
All right, could I please see what it is that you're asking to have admitted?
Absolutely, Your Honor. It's going to be page 65 of the document that you have in front of you, Exhibit 39.
Okay.
And it'll be lines 164 to 176.
Okay, let me take a look at this before we begin any arguing. So 164 to what?
Yes, Your Honor. It'll be lines 164 to line 176.
All right, what's your objection?
Yes, Your Honor, we have another 702 objection, specifically to the expert content contained in that passage. May I be heard?
Yes.
You know, part of that passage includes several sections about how if you use certain numbers, the parachute will inflate at a certain time. Specifically, Your Honor, they talk about how if you give the signal 9 seconds, Ms. Devin says that's cutting it too close. Your Honor, that's an expert opinion. It's something you need expertise to do. And they have to lay that foundation on the record as the proponent of the evidence.
What's your response to that?
Yes, Your Honor. The passage with the numbers and calculations that Mr. Hubbard is referring to at this time, those are Mr. Doy, the defendant's representative's own comments. Clearly, Your Honor, those are a lay witness opinion about what those numbers would mean, and they're not being used to indicate any kind of expert opinion to the members of the jury at this time.
So you're saying that there's no foundation needed for those numbers? What's your response to that?
Your Honor, we respond in 2 parts. First off, because there are Mr. Doig statements, that makes it more inadmissible. Mr. Doig isn't an expert. He can't testify in court and onto the record that if you do certain things with certain calculations, certain results will happen. That's not part of his expertise. On the second part, Your Honor, she still didn't cover the fact of Sky Stebbins talking about, well, that's cutting it too close if you do it at 9 seconds. That is surely an expert opinion.
May I be heard, Your Honor?
Yes, briefly.
Your Honor, under Rule 701A, witnesses who are lay witnesses can testify to what is rationally based in their own perception. We've heard today that Sky Stebbins was the stunt coordinator for that set. It wouldn't take any kind of expert opinion on her part to testify to her opinion on the situation.
All right, the objection is overruled. Those lines will come in, not necessarily that that is an expert opinion, but that is what was said by this particular individual, and it's not necessarily because it's true.
Yes, Your Honor.
Because it's in fact safe. All right, so that objection is overruled, and this, unless you have any other basis for objection, the lines from Exhibit 39 will be admitted. Are there any other basis for the objection?
No basis for objection, Your Honor, but we too then would like to read on some parts of that same affidavit.
All right, and what's that you're talking about for context?
Yes, Your Honor.
And what sections are you interested in having admitted, which you can do in your case in chief? I'm not going to make those rulings now.
Yes, Your
But
Honor.
if you would like to keep that in mind, and when you present your case, we can talk about that. But for now, the objection is overruled, and those portions will be admitted. With that, does the plaintiff rest?
Your Honor, we'd actually like to read these onto the record at this time.
All right.
We have remaining time in our case.
Okay, go ahead.
Mr. Ryder, go ahead and take the witness stand, and we'll read her names here. And make sure you have them, please.
Please identify when it says Q&A who is speaking.
Yes, Your Honor. Plaintiff's counsel. Question. Before you left, did you discuss the possibility of doing an additional take of the stunt?
Yes. On June 20th, before the group dinner, Cole Doy pulled me aside. Doy asked if I thought we could do one more take of the motorcycle stunt on June 21st, except this time, Doy would delay giving the signal until Peter had been in the air 9 seconds. Doy said, I used your numbers and worked it out. If I give the signal at 9 seconds, the parachute will be inflated by 13 seconds. Peter is still above 1,000 feet. That's still safe.
Question. How did you respond?
I said no way. That's cutting it too close, especially when I'm not there.
Question, why did you think that was cutting it too close?
The parachute could malfunction, the headphone could malfunction, and then you've got an emergency.
Question, what did Doy say when you said no way?
Doy said, okay, then we won't do it.
Your Honor, with that, the plaintiff rests.
All right, then that particular portion will be admitted subject to additional portions for context.
Yes, Your Honor.
Yes.
Maybe start our case in chief with that.
Yes, and so the plaintiff has rested. You may start your case in chief. Go ahead.
Yes, Your Honor, and I'll just read from the excerpt. So for Your Honor's reference, that's the last page of Sky Stebbins' affidavit, starting on lines 203 to the very end.
All right. Yes, go ahead.
Sky Stebbins' affidavit. Question.
Objection, Your Honor. I apologize for the untimeliness. We didn't quite know what sections were being read. But we do have an objection under Rule 408, a prohibited use of a compromise offer in negotiation. May I be heard?
Yes, go ahead.
Yes, Your Honor. If we take a look at these last sections that Mr. Hubbard is attempting to use and onto the record right now, they discuss Sky Stebbins engaging in a settlement with the Jones family. Your Honor, Rule 408 is clear that such discussions of compromise offers, negotiations, or settlements just like this cannot come onto the record in court. It diminishes the entire purpose and willingness of parties to engage in those compromise offers in the first place.
And what's your response?
Yes, Your Honor. Rule 408 is a little more narrow than Ms. Debnath led you on to believe. Your Honor, in Rule 408, it says it's prohibited specifically to impeach by prior inconsistent statement or to prove or disprove the validity of a disputed claim. Today, we're not doing that. We're using this as an exception to Rule 408 under Rule 408B, where it says the court may admit this evidence for another purpose, such as proving a witness's bias. We're going to prove a witness's bias today by showing that the Jones family made an agreement with them to testify in exchange for not suing. That's permitted use.
May I be heard?
Yes, briefly.
Yes, Your Honor. It states in Rule 408A that's a prohibited use for the disputed claim in this case. Mr. Hubbard is using this testimony of the settlement to show the credibility of the disputed claim goes in their favor, Your Honor. That's a prohibited use under Rule 408.
Okay, and so I understand your contention. You're asking for this to be admitted to prove bias.
Yes, Your Honor, prove witness's bias.
All right, and so on that basis alone, those lines 203 to 209 will be admitted, and there will be a limited instruction during the jury instructions to the jury to consider it only in terms of bias.
Yes, Your Honor.
You may both be seated. Do you have other witnesses?
Your Honor, may I read the lines on?
Yeah, oh yes, I'm sorry, I thought you had done that. Go ahead.
Question. Were you originally a party to this lawsuit? Answer. Yes. At first, the Jones family sued my company and Dragon Studios, but then I settled with the Jones family. Question. What were the terms of the settlement agreement? Answer. The settlement agreement releases me and my company for liability for Peter's death and says that I agree to testify for the plaintiff in this case.
All right, so those particular lines will be admitted for the purpose of bias. With that, counsel, do you have any witnesses to call at this time?
Yes, Your Honor.
You may call your witness.
Defense calls Kunde.
Good morning.
And actually,
Yes, please.
could you please introduce yourself to the members of the jury?
Good morning. My name's Cole Doy.
What do you do for a living?
I'm a producer and the founder of Dragon Studios, so I help make movies.
How'd you get into that?
I knew I always wanted to be in Hollywood, and I started out as an extra on set. I kept trying to track down the producer to give her my feedback. She didn't like that. So after I was fired, I started working to be a producer myself.
Sir, do you know who Peter Jones is?
I do. Peter was a close friend of mine. We'd worked on movies for the last decade together.
Sir, were you in the courtroom today during trial?
I was.
Did you hear Ms. Debnath talk about how you didn't give the call to Peter?
I heard that, sir.
Is that true?
No. Absolutely not.
I want to back up for a second. Let's go back a year, starting with that team. Sir, did Dragon Studios hire a team?
Yes, sir. It was our plan to protect Peter. So we hired a team to make sure that stunt he was doing was absolutely safe.
What kind of team?
A team of experts. We hired crew members and a team of people who knew safety for stunts like this.
Sir, what did that team suggest you do?
They suggested we make a safety plan, something that Peter could follow so that when he did that stunt, he was safe.
Would you recognize a copy of that safety plan if I showed it to you?
Of course.
Sir, if you could flip to Exhibit 34, and Your Honor, I can approach with a copy, or you may already have one of this one.
Thank you, but I'll take that, thank you.
And Your Honor, since this has already been admitted, may I publish it to the jury?
Yes.
Mr. Doig, so tell me about this plan. What's in it?
Sure, this plan lays out exactly how we were going to keep Peter safe when he was doing this stunt. So that's the technology he was going to use, that's the training he was going to undergo.
And what was the stunt he was supposed to do?
Peter had come to me with an idea to drive a motorcycle off of a cliff, to let go of that bike and to pull out a parachute.
I want to take those one at a time. Let's start with the motorcycle. Did Dragon Studios provide or give any preparation to Peter to use that motorcycle?
Of course. In this plan, we laid out that he was going to try and use that motorcycle, and we had set up this whole ramp for him in California, so it was close to him and he could practice. We wanted to make sure that was safe.
You said you set up a ramp from California. Would you recognize that if I showed it to you?
Yes, sir.
Sir, could you flip to Exhibit 10? I believe this one of the
I think
exhibit.
we got it here.
Sir, describe what you're seeing in that photo.
Sure. So this is the ramp we had constructed for him here in California. It's just like the ramp we were going to construct at the top of that mountain. It has the same scaffolding and the same angles.
And how many times did Peter practice on that ramp?
We mandated he practice 500 times before getting up on the cliff.
Objection, Your Honor, lack of foundation. May I be heard?
Yes.
Mr. George has said that we mandated Peter practice 500 times before getting on that cliff. The jury needs to hear what form that mandate took. Was it a verbal instruction to Peter? Was it written in something that he signed? That foundation is important for the jury to hear to understand the extent of what they're calling a mandate.
May I respond, Your Honor?
Yes.
Your Honor, that mandate came in the form of evidence Ms. Debnath put into evidence on the stunt plan. If you see at that top bullet point, performer will prepare by completing at least 500 skydives and 500 motocross jumps. It's on the record.
The objection is overruled. Go ahead and, did you answer the question?
Yes, I did.
Okay.
So you said 500 motocross jumps. What about the skydiving part? What did you do there?
Same deal. 500 jumps skydiving. We start at higher altitude so it's easier, and slowly he'd work down to get lower, learning how to skydive as he went.
Okay, so if we talked about that team and that training you did, I want to talk about if you used any technology to help Peter. Did you?
Yes. Two main pieces. The earbud that he was going to be wearing in his ear so we could tell him when to pull his parachute, and the parachute itself. It was a quick open parachute, would open in a few seconds.
Sir, I want to talk about that earbud. There's been a lot of conversation today about the day of. So can you set us up for what happened that day when Peter died?
Yeah, it was just like the day before. We had set up just like that day, and Peter was going to drive his motorcycle off the cliff. But this time we had agreed to wait 9 seconds, a little bit longer before Peter was given the signal to pull out that parachute.
Sir, when you say you agreed to wait 9 seconds, who all was there when you agreed?
I had spoken with our safety expert about it, gotten it cleared, and then I'd asked Mr. Jones about it himself.
Was Miss Ellie there?
I believe so.
So, sir, now that we know that you got it cleared, let's go back to the day up. When you were in the control room, what happened as Peter went off that ramp?
We have a clock in the control room, and that's what tells us the time to radio to Peter in that earbud when to pull his shoe. So as Peter goes off the cliff, I'm watching the clock. And at 9 seconds, I tell Peter to pull his parachute. But I can see on the cameras that he doesn't. So I start radioing again, deploy, deploy. I think it was too late.
Sir, did you make sure that that call came through?
I did everything in my power to try to get my message to Peter. Everything.
Thank you for your time.
Okay, let's have cross-examination.
Yes, Your Honor. Good morning, Mr. Doyle.
Good morning.
So let's start with some easy questions. You're
Okay.
the founder of the defendant in this case, Dragon Studios, right?
That's right.
Sir, you built that company from the ground up, true?
That's right.
You've been its president since it was founded all the way back in 2006, right?
Correct.
So that company that you built from the ground up, that you're the president of, is on trial today.
That's right. That's why I'm here.
It's being sued for negligence.
That's right.
Certainly you don't want your company to be found liable, do you?
No, I don't.
With that in mind, let's talk about what you said about the call you claim you made on June 21st, 2023.
Okay.
And I actually want to take this in 3 parts because you remember Mr. Jones mentioning the team, the training, and the technology, right?
That's right.
Okay, so let's work backwards here. Let's start with the technology. I'm going to approach and retrieve the earpiece from the jury. Sir, this earpiece that I'm holding, you're aware that Mr. Jones was wearing this at the time of that fall, right? June 21st?
That's right. That's the earpiece we had bought for him.
Right, the earpiece you bought from him, and after he died, you actually retrieved this earpiece, right?
That's right.
You tested it.
I had one of the crew members test it. That's right.
You had one of the crew members test it. They reported to you that it was working, true?
Objection, Your Honor. Hearsay?
Have you heard, Your Honor?
Yes?
Your Honor, this is for the subsequent action of Mr. Doyle.
So it's not offered for the truth of the matter asserted?
Yes, Your Honor.
What's your response?
Your Honor, we just have an offer of proof of what that subsequent action is.
All right.
Yes, Your Honor. It's going to go to Mr. Doyle's statements after hearing that Mr. Jones had fallen to his death, what he said.
All right, so I'm going to overrule the objection at this point. It can be renewed unless the foundation is not made. Go ahead.
Yes, Your Honor.
So your understanding was that this earpiece was working at the time of his fall, true?
I was told it was working on the ground that day.
Okay, so given that he had this technology in his ear, let's think through how you approached the aftermath of his death. Sir, after you learned that Mr. Jones had plummeted to his death, you didn't say, "Why didn't he listen to me?" Did you?
No.
You didn't say, "Why didn't he deploy his parachute?" Did you?
No.
Sir, what you said was, "I wanted a longer shot." Those were your words.
That's right.
You said, "I thought we had enough time." That's what you said after Mr. Jones died.
I thought we did.
So let's talk about why you might have wanted that longer shot. I'm holding what's been created as Exhibit 25, sir. This is the movie poster for the movie, right?
That's right.
I mean, when you look at this movie poster, it's clear that scene, that stunt, it was important to you, right?
It was.
You put it on the front of this poster.
We did.
And so that franchise in its entirety, it actually made millions of dollars for your production company, true?
That's right.
So even after 6 successful takes where Mr. Jones landed safely, that was not enough for you, true?
We thought we could make the scene longer. That's
You
right.
thought you could make the scene longer, so you decided to do a 7th take with a longer fall, true?
That's right.
So let's compare the original plan to that 7th take. Because, sir, the original plan, Mr. Jones was supposed to free fall for 4 seconds, right?
Right.
We can agree that in and of itself was dangerous, right?
It was definitely a dangerous plan.
Sir, then, you decided the new plan, he would free fall for 9 seconds, true?
That's the one I cleared with our safety coordinator.
Certainly, that 9-second free fall was even more dangerous.
Objection, Your Honor. It's a 7-2 opinion. Evaluating the danger levels between the time it takes to fall.
Go ahead.
Yes, Your Honor. It doesn't take an expert to understand that the closer you are to the ground when you're falling, the more dangerous it is. It's a legal
Overruled. Go
Yes,
ahead
Your
and
Honor.
answer.
9-second free fall, that's more dangerous than 4-second free fall.
Absolutely. That's why I went to our safety coordinator.
Well, so you're saying you went to the safety coordinator, but surely because this new plan was more dangerous, you have that safety coordinator walk through every single detail with him, right?
No.
Okay, well, and then I'm looking for a number here. How many times did you have Mr. Jones run the extended fall with a harness before he did it for real?
We never had that.
I'm sorry, sir, are you telling this jury that number is 0? You never had him run the extended fall with a harness?
That's right.
So let's walk through what happened. Because that extended fall, it was originally your idea.
Yes.
You're not a stunt coordinator.
No, that's why I went to one.
You're not a professional diver.
No.
Sir, after Mr. Jones ran that extended fall with no harness, he died.
Yes.
Sir, Mr. Jones, he's not an expert in skydiving safety, is he?
I don't think he's an expert in safety. No.
Sir, you're aware that he's not an expert in designing his own skydiving plans at all.
No.
You're aware that he never even sets his own deployment altitudes, right?
That's right.
You're aware that he relies on his team, his production team, just like Mr. Hubbard said.
Yes.
But here's the thing, sir. On June 21st, 2023, his production team was not in that control center, were they?
They weren't in that control center. It was me and Miss Guglielmo.
2 people. You and Miss Guglielmo.
And crew people stationed there that day.
So let's talk about who was actually inside that control center. When it came to that team of people, they weren't there.
That's right.
The only people who were was you. You were to make that call.
I was the one to make the call. That's right.
Nothing.
Do you have redirect?
No redirect, Your Honor. We just ask that this be excused.
Yes, the witness will be excused, and then I understand, do you have any further evidence, or do you rest at this time?
We rest at this time, Your Honor.
All right, thank you. And what we're going to do at this point is allow the counsel to take a moment to gather your thoughts for the closing. And I'm going to ask the judges to go ahead and mark your ballots up through, or up until closing argument, because we do have everything ready to go on that. Yes,
Yes,
you have
Your Honor.
something?
Your Honor, just a slight evidentiary issue that I don't think we settled
Okay.
before. It was that last bullet point of that stunt
Yes.
plan according to the, the 2,000 feet.
That's correct.
I understand the court held that in advance.
That's right.
Just like to
Thank
do
you.
my motion to strike that.
Your Honor, may I be heard?
Yes.
Your Honor, we heard foundation on the record from the excerpts we read from the affidavit, or excuse me, Your Honor, the prior deposition
From the
of that
deposition.
stunt coordinator. Sky 7,
Okay,
Your Honor?
let's look at that again and see if that cures that. Okay, so that says. see how the statements from that particular, the excerpt from that deposition cures the issue there.
Yes, Your Honor, if I could try to explain?
Yes.
Absolutely, Your Honor. So we discussed earlier how this statement, it's not being used to give the jury any kind of definitive expert opinion. It's only being used for the impression that would have been given to this representative of the defendant and Mr. Jones, who both signed this document. Your Honor, this testimony that was read onto the record from Ms. Stebbins, that stunt coordinator, it shows exactly what that effect was. That she told them explicitly what they were doing was not safe. It goes to the effect, both in this deposition and in the stunt plan itself.
Your Honor, may I respond?
Yes.
Your Honor, earlier when the court held this in advance, Ms. Debnath promised the court that she was going to show testimony from Stebbins, that this was an expert that could also testify to that same information. The deposition does not match the stunt plan.
May I be heard?
That's not the foundation they needed to lay.
I'm
And so
sorry.
the court should strike it. We asked the
Go
court.
ahead.
I'm so sorry for jumping the gun, Your Honor.
Thank you.
Your Honor, I want to be clear that in the opening statements, we never promised that an expert would say the industry standard is 2,000 feet. That's not what we said. What we said was that the stunt coordinator, Sky Stebbins, that testimony read onto the record and was admitted, would say that the new plan was not approved. That's exactly what we read.
All right, I'm going to go ahead and sustain the objection and strike that paragraph. The exhibit will be admitted with that paragraph stricken. I don't think sufficient foundation has been laid. Now with that, I understand both sides rest, and you can go ahead, yes?
Yes, Your Honor, just a brief point of order. The only objection was to the 2,000 feet above ground level, that first sentence of the last paragraph. The rest of it are just the instructions as to when the skydiver would descend. Those we'd ask to be admitted.
Okay, I think that's a good point there. So it will be the first sentence where it states, according to skydiving industry standards, a skydiver should have their parachute open and fully inflated before the skydiver descends below an elevation of 2,000 feet AGL above ground level. That sentence will be stricken. The rest is simply the plan. So I think you are correct in that sense, and you are correct that there's been no foundation for that first sentence, that is an expert opinion that requires some foundation. So with that particular amendment to number 34, that will be admitted, and I understand both sides rest.
Yes, Your Honor.
And at this point, I'm going to let you collect your thoughts and ask our scorers to start their scoring. So we'll take just a couple minutes, and everyone will remain in the courtroom. All right, are we ready to start the closing argument?
Yes, Your Honor.
All right.
Yes, Your Honor.
Good, you may proceed.
This case is about the call that never came. Members of the jury, defense's counsel got up here in opening statements and they said that, well, this defense, they hired a team of experts. They mandated training. That he was even given this earpiece to keep him safe. They said that their plan was to protect him. Members of the jury, we agree that was the original plan. But then we learned that plan changed. And when that plan changed, that call never came. So they failed to protect him. Members of the jury, that failure is exactly why we brought a claim of negligence against that production studio, this defendant. Now, in doing that, it was our burden to show you it's more likely than not that the production studio broke their promise to Mr. Jones to keep him safe. And that breaking of that promise, not making the call, that's what killed him. So, members of the jury, what I want to do now is take the time to go through exactly how we proved up that case, exactly how we proved to you it's more likely than not that this production studio is negligent. Start with fact number one. They did too little to make sure that stunt was safe. Now, members of the jury, this goes back to a couple of things, but in particular, let's start with the defense's claim that there was enough training to complete this stunt. I want you to think back to the testimony of Mr. Doyle. Because we agree, he did 500 motorcycle jumps. He did a bunch of hours of dropping that motorcycle with a harness short. But then I asked Mr. Doyle, I was standing right back here. I asked him, how many times did you have Mr. Jones practice that new stunt with the extended fall with a harness before he did? Do you remember what his answer was? 0. The defense, they can get up here and try to talk to you about all the training that Mr. Jones did prior to June 21st, the day that he died. But here's what matters, members of the jury. That plan to protect him that they keep talking about, it changed. That plan went from a 4-second free fall to an infinitely more dangerous 9-second free fall where he was closer to the ground, closer to his death. And when that plan changed, they did nothing to protect him. No practice, no training, 0. So they let him fall too low. And that's fact number 2. See, members of the jury, we heard today testimony from a stunt coordinator who couldn't be here in court. But we heard that stunt coordinator say that she never approved that revised plan with that 9-second fall. Why? Because it wasn't safe. See, Mr. Jones, Mr. Hubbard wants to talk about the training. But the problem is that with all of that training, that team wasn't with him. That stunt coordinator that they were talking about, who apparently approved this plan, according to the defendant's representative, they weren't even there on June 21st when this accident happened. So if you want to talk about that team in that room, members of the jury, where was that team? There were 2 people standing there, watching the screens. And there was only one person who was responsible for giving him that call in this earpiece, that call that never came. That team wasn't there. Members of the jury, that means that when they tried to make that call at the very last second, it was too late. Now, members of the jury, I understand there's been a bit of dispute in this case between whether or not that call was made. And I understand the defense, they might get up here, Mr. Hubbard might get up here and try to tell you that it was a he said, she said. And then if it's a tie, that goes to the defense. But here's the thing, members of the jury. That's why we have you. Because it's your responsibility, your job to understand and assess the credibility of each and every single witness who took that stand. I know there weren't a lot of them, there were only 2. So let's go through them. First, Allie Goody. Members of the jury, she's got no dog in this fight. Nothing to gain from this lawsuit. Members of the jury, she came here to talk about the death of her friend. To tell the truth about what happened to her. But as for the defendant's representative, the founder of that company, what do we hear? That company he built from the ground up. It's on trial today. In terms of that reputation, he's got everything to lose. But all right, let's play into the defense's world for just a second. Let's throw on the look. Let's say that the earpiece was working and well, they gave that call. Members of the jury, what exactly are they asking you to believe? Because we heard today that Mr. Jones, as the defendant's representative was aware, had no safety training. He wasn't the one to plan any of the safety for those stunts. He was relying on his production team to do that for him. He relied on them to keep him safe. So they're asking you to believe that when he got that call, the call that was the only thing standing between him and imminent death, he what, just ignored it? That he had a death wish? Does that make sense to you? Because here's the thing, members of the jury, when you walked through the doors of this courtroom, you didn't leave your common sense behind. You know, that came with you too. So you get to ask yourselves, is that reasonable? It's not. It's not even rational. Members of the jury, at the end of the day, it's our job to hold this company accountable for what they did. That call never came. And it caused Mr. Jones's death. Find the line. Thank you.
Thank you, Ms. Debnath. Mr. Hubbard, do you have any closing argument at this time?
Yes, Your Honor.
You may proceed. Yes.
Our plan was to protect. Members of the jury, by now, you've probably seen a difference in the way me and Ms. Debnath try this case. From the beginning, opposing counsel has been focused on moments. Little ones. Moments like Peter being up on the mountain. Moments like flying off that cliff. Moments like waiting for that signal. And while we can agree those moments are important, and those moments very well may decide this case for you, it's not enough. You can't just look at those moments in a vacuum. You have to use context. Evaluate all the evidence you were given today and decide, do those moments make sense? Is what they're telling me make sense? That matters. Members of the jury, because in a case like this, when a plaintiff is suing a company for negligence, it's not enough just to prove that they broke a promise. Ms. Debnath told you she was going to prove that we broke our promise to Peter, and that when we broke our promise, it killed him. But it's not just about whether the plan changed or not. It's not just about whether it went from 4 seconds to 9 seconds. It's about what's reasonable. It's about whether this company acted reasonably to protect its employee. Your question is, what would a reasonable company have done? And in that, well, we showed you that. About an hour ago, I told you I was going to break this case down into 3 things. Remember that? It was the team, the training, and the technology. I'll make good on that promise. Let's run through it one last time. Start with that team. Members of the jury, you heard today the amount of people involved in this operation. And no matter how many times they want to focus on the moment of that jump, or how many people were there, think about all the people that were there over the year. You saw photos of what that site looked like. Mass ramps being built, construction everywhere. He had a team. He had a team to keep him safe. And that's important, members of the jury, because when you look at the actions of a company and are trying to decide if they're reasonable, what do you believe a reasonable company would have? People to protect. So what about that second part, the training? You sure heard a lot about the training from both witnesses. This is something that both of them can agree on. That studio mandated 1,000 different instances of training. Remember, you heard 500 motorcycle stunts, 500 skydiving stunts. It's important because it shows you that it was their plan to protect him. And that training does matter. The instances before that moment does matter because it goes to show you that they cared. So what about that third one? The technology. You've heard two very different stories today. I won't lie. One witness told you that I didn't hear him say it. Mr. Cole told you he did. But instead of doing what Ms. Debnath was talking about, well, it's 50-50, defense wins, I want you to think about this. Look at the context around the moment. This is a man who spent millions of dollars training somebody to be safe, building things to keep him safe, built his movie, a production company. Ms. Debnath told you they made millions of dollars off this movie. They want you to believe he just let him die? It's not reasonable. And you'll see that. When you look at the context around the moment, you'll see that it was our plan to protect him. That matters. Let's take a second and think about all the reasons why Dragon Studios would want to protect him. Because members of the jury, a movie company that can't keep its actors safe, a movie company that's losing their movies left and right, that doesn't make sense. The company wouldn't want to do that. Doesn't make good business sense. Doesn't make sense ethically. And that's the kind of reasoning we want you to follow today. Because members of the jury, in a few moments, the judge is going to give you a set of instructions. She'll tell you. Today you can and you should use your common sense. Use your experiences in life to tell you what you believe happened. Interpret the evidence through the lens that you've seen. And that's all we've ever asked of the plaintiff to do today. Make it make sense. Members of the jury, by now, I hope, I trust that you've seen our plan was always to protect. Thank you.
All right, do you have a rebuttal argument?
Yes, Your Honor.
Please proceed.
Members of the jury, when that plan changed, the moments are what mattered. Moments meant the difference between the call that could save him and the silence that killed him. There was no team with him the day that he died. There was no extra training for that more dangerous stunt. And as for the technology, what good was it when there was no call? That parachute signal was not Mr. Jones's call to make, it was theirs. Find the line.
All right, I understand this concludes the trial. Now I'm going to ask the scorers to go ahead and submit the score sheets, and then we'll get a few quick comments from the scorers.